Mr. Chairman, members of the committee, my name is Kirk Presley. I'm an attorney in Kansas City. I do a fair amount of this work. In fact, I think I've got a case pending or have had cases with everybody who's testified here. And so to review and put this in context, let's look at our existing law, because if it ain't broke, don't fix it. If an insurance company does a reasonable investigation of the claim, comes to a well-researched and reasoned opinion on coverage, and denies coverage and denies a defense to that insured, they are off scot-free. They have zero liability. And I'll give you the case. It's a case Clay Crawford beat me on for Travelers Insurance, where I represented a small doctor's practice called Kansas City Gastroenterology. In that case, we reduced that claim to judgment. We asked the court to find whether or not there was coverage. We also asked for bad faith and a breach of the duty to defend, and the court said there's no coverage, and if there's no coverage, there's no duty to defend, and there's no bad faith. End of story. End of story. Travelers versus Casey Gastro. Conceivably, as this bill is drafted, that's potentially one of the cases that's going to be overruled, because that would follow along in the same vein as Butters versus City of Independence, Whitehead versus Lakeside Hospital. And if you look at those citations of things that's interesting, and I found myself in this position numerous times in my practice. I represent claimants, I represent insureds, and when I represent insureds, they're typically small businesses, medium-sized businesses, and I can give you the citations to the resolution of those cases. And if a carrier denies coverage for which an insured thought he was paying the premium, and he does not get the value or the benefit of either a defense or the indemnity under that policy, it is potentially devastating. And I'll give you the specific example of Dodson International versus National Union Insurance Company. Dodson had to take Chapter 11 after a tendered but refused coverage claim resulted in $1.5 million judgment. It's a $20 million company, but they couldn't have available cash to pay that kind of judgment, and they had to file Chapter 11. So while I appreciate Mr. Adkins coming on behalf of the chamber, but I actually represent his members in these cases, and they can be financially devastating if they are handcuffed, as this bill would have them be, such that they cannot enter into any settlement agreement that would protect themselves. Then bankruptcy is perhaps the only alternative for them. In fact, there are reported cases for individuals who don't have those kinds of assets and resources and access to lawyers, and that's exactly what they do. They go to the bankruptcy court, and the trustee then investigates the claim for improper claims handling, and that's the Ganaway versus Shelter case. And so under the existing law in the state of Missouri, the insurance carrier has three options when it's presented with a liability claim by its insured. It can defend and indemnify, which is what the policy required. It's a covered claim. They can choose to defend under a reservation of rights, and as that term is commonly known in Missouri, that means we're going to give you a defense and we're going to reserve the right to evaluate the coverage when further facts are known and make a decision on that. And that's not quite how this bill defines reservation of rights. Under this bill's definition of a reservation of rights, a complete denial of a defense and indemnity could take place. And they would simply label it a reservation of rights pursuant to this statute. And so I think Mr. Garner's correct that we're going to see a great number of increase in the amount of denials, because if the reported cases that we see, and albeit a small percentage of them, those cases still exist, and they come from poor claims handling, they come from intentionally deviating from the claim standards, and that's how these claims come into existence. They ignore existing law, they do a result-oriented investigation, where I would take a statement from grandma and I would say, Grandma, your grandson didn't have your permission to use that card, did he? He was grounded, wasn't he? He didn't have a right to use that card, did he? Yes or no, Grandma? I've seen statements exactly like that and used as the basis for denial of coverage. And so when we're looking at the fundamental fairness and the equities involved here, you have to ask yourself, where are we going to go with this? If we're getting this kind of claims handling misconduct, if we're getting this kind of activity on behalf of the insurers, when they face what, according to these gentlemen, are extraordinary judgments, then what's going to happen if they're completely insulated? And the reality is, under the existing coverage, under the existing law in the state of Missouri on coverage issues, where there's a dispute, it's a simple procedure. You file the DJ, the declaratory judgment, the carrier can do that, and the carrier has the right to go to the trial court in the underlying case and ask that it be stayed until you get a ruling on the DJ. And that case is Colonna, spelled differently with a G than your committee member, Mr. Colonna, but it's Colonna versus Farmers and Merchants. And there the trial court stayed the underlying wrongful death claim and said, we're going to sort the coverage thing out first, and then we'll see how it checks out. So under the existing law, the carriers have the ability to expedite that proceeding and reach a coverage determination. But a lot of times it's to the carrier's benefit not to do so, because with uncertainty they can then apply pressure to the insured to contribute its own assets or finances to effectuate a resolution of the settlement. And if the insured, Mr. Colonna, asked, why can't everybody just sit down and work this thing out? Well, the reality is this bill prevents that. In 417.4, it says the insured who's being defended under a reservation has a duty to cooperate. And that means that the insured is not free to go and protect itself under such terms as it may deem advantageous to itself. I've asked all of these gentlemen at one time or another to do that on behalf of insureds. I guarantee it, guys. You tell me if I'm wrong, but I guarantee you, I've got a case right now with Mr. Beckman. I've got a case right now with Mr. McCausland where he represents the insurance carrier. And I just finished the case with Mr. Crawford. And so in all of those cases, that insured is between a rock and a hard spot, because the carrier's denying coverage and he's left, his carrier's abandoned him. So now he's got to come up and pay for a lawyer out of his own pocket, incur the cost of defense. And many times, especially with these frivolous claims, the cost of defense is almost as important or more so than the right to indemnity. So what this bill really is seeking to do is to overturn about 50 years of the common law of Missouri, which has struck a very fair balance over the course of time to balance the interests of the insured and its right to be heard and to make good faith decisions regarding its coverage and exposure on behalf of its insured, and giving protections to the businesses and individuals who are the policyholders of this state to protect themselves, because a carrier could be right. And in fact, in Mr. Crawford's case, Travelers was right. But fortunately, we were able to negotiate an agreement with the claimant. It was an employee discharge claim. And we were able to negotiate an advantageous agreement for the business to protect itself. As it turned out, the original claimant in the underlying case, Dr. Brand, his judgment went unsatisfied because we lost the coverage. And so my clients were able to take advantage of that. And under this bill, they will not. Under this bill, they were not. So, the last state of the existing law, there have been several inquiries as to where Missouri fits in this. And I find it interesting that these gentlemen would use Kansas as an example. Kansas does not use the tort of bad faith. It uses a negligence standard. If the insurer negligently fails to resolve the claim within the policy limits, and when it has the opportunity to do so, the excess judgment, the surplus judgment, becomes the claim of the judgment creditor, just as the court did in our state in Columbia Casualty. And so in the Kansas proceeding, that claim belongs to the judgment creditor, and all they have to do is prove negligent claims handling, and the damage is the amount of the excess judgment. It's precisely what the court held in Columbia versus Higher Holdings. And so when we look at the existing state of the law, I would refer you, and this probably gets a little wonkish, but the American Bar Organization has a white paper on this. It's called Reservations, Required or Not. And in there, they will footnote the jurisdictions that allow either the insured to reject a reservation, or a tender defense under a reservation requires the assent of the insured. And off the top of my head, I think they're Texas, California, Illinois, Vermont. But every state is different. Some states require negligence, like Kansas. Some states allow the judgment creditor to pursue the claim directly against the insurance company, like Kansas. And if we want to go to that route, that'd be a subject of discussion for this committee, I would hope. But that's not how the common law has evolved in the state of Missouri. Common law has evolved into this status. And so these gentlemen are correct that the insured can reject that reservation under rights and proceed to protect itself. But at the same time, the insurance carrier has the opportunity to go and pursue a declaratory judgment and seek a stay in the underlying proceeding. So I hope I haven't been too technical, and I hope I haven't said anything that Mr. Colonna thinks is not the way he practices.
Representative Colonna. Is there a record for how many times I can recognize you in a meeting?
With all of the experience we have here on this committee in the insurance industry, I'm surprised I'm the only one that's asking questions. But to briefly inquire, Mr. Chairman.
Yeah.
Oh boy, I could never aspire to practice the type of law you guys do. That's some highbrow stuff. But I want to make sure that I'm being serious. I get by on my charm, but anyway.
Obviously.
So, so for our non-lawyer friends in the audience, a stay means that, and I'll use the gentleman from Springfield's example, while that federal court is trying to determine whether or not there is coverage, a stay means that that initial lawsuit is put on hold, correct?
That's exactly right. I mean, I was being facetious, obviously. You have a good command of exactly what we're talking about here today, and that's precisely what the responsible carriers will do. They'll come in, they'll ask the court for a stay. Most trial judges I know are going to grant that. They're going to say, well, that'll stymie the cost of defense. So if there's no coverage, then the insurer's not going to be out a bunch of defense costs under that. And I won't be wasting time with some deal that nobody's going to pursue if there's no coverage. So, yeah. Thank you, Mr. Chairman.
Thank you. Make sure you fill out this form. Anyone else here testify in opposition to 1344?